Hello, everyone, and it is just after 1 o'clock, so welcome for this Monday webinar. My name is Martin Daly. I'm the Director of Water Quality Programs for the Capital District Regional Planning Commission. I want to welcome you to today's webinar, Marijuana Planning and Zoning Panel. We're going to be beginning shortly, but before we get underway, I do want to take the opportunity to promote a couple of CDRPC programs. One is we have a technical assistance offering with what I call our sister agency, the Capital District Transportation Committee, and we match our land use and data services expertise with their transportation planning expertise and really work on corridor projects within municipalities of the 4-county capital region. That's Albany, Schenectady, Saratoga, and Rensselaer. So if your community has a specific idea or concept that they're interested in receiving some technical assistance for, please reach out to us. This is a great program. We've helped a number of communities in the Capital District to lay the groundwork for some really innovative transportation and planning projects. So can't recommend that program enough, and looking forward to seeing some great applicants. Second, we like to shine a spotlight on work that sometimes doesn't get enough credit. This is our Erastus Corning II Awards for Intermunicipal Cooperation. They're now open. Our deadline is approaching, but you have some time to put together applications, and we recognize that the CFAs are also the big three letters that people are focusing on now. So our application deadline is quite generous in August, but want to put this out there because we like to celebrate the work that communities are doing beyond their boundaries. The awardees, our eligibility includes municipalities, but also nonprofit and non-governmental organizations. So if you know of a person or a project that would be great to shine a spotlight on, please let us know. The award application is very simple, and we're looking at putting together an event in the fall to celebrate our awardees. So with that, let's get underway this afternoon. I do want to mention that our attendees join with their video and audio off for security purposes, but we'd like you to be engaged. So please use the chat function or the Q&A function to submit questions. I'll relay those on to our panelists for today's session. I'll interject where I can. Hopefully, it'll take the flow from them. We do archive our presentations. This is live streaming on YouTube, and it will be posted to the Eventbrite page at the conclusion of the webinar. That link is the same link from which you selected to sign up for webinars and to join in on any of the webinars in the series. Speaking of the series, all the webinars are archived on that same page, so you can find resources on the Eventbrite page. And finally, we get this question a lot: when do I receive my credits? Well, municipalities have a wide latitude in accepting sessions for eligible 4 hours of training that planning and zoning board members are required to obtain per year. What we do after the webinar for people that joined us with an email address is we automatically send out an email 24 hours after the conclusion of the webinar. You may submit this email to your municipality for consideration of credit. Once in a while, we do get a note that people aren't receiving these, so please check your junk mail settings to make sure that you get the email. And if you don't, contact us, and we can certainly work to furnish you with an email manually. But that should be all your municipality needs for consideration of credit for the webinar. We've also submitted this for CM credits for AICP members out there. So remember to look this up on the APA website. And you can be able to access information for this webinar to be able to get your CMs. All right, so let's get into the meat of today's session. We're going to provide an overview of the provisions of the law that will impact planning and zoning for decision makers. We're going to highlight the discretion communities have in implementing this law related to marijuana zoning. We can foreshadow the regulatory landscape, and we'll explore some lessons learned from other states that have implemented guidance relating to recreational marijuana. I'm really pleased that Wade Beltramo is joining us. He is from the New York State Council of Mayors. Is that correct, Wade? Conference of Mayors?
Conference of Mayors, yes, yes.
And then we have our own executive director, Mark Castiglione, joining us as well to provide some context in the planning realm. So with that, I'll hand it over to Wade. Wade, I stole your screen share, so you may need to put that up again if you're interested.
Here. There we go.
So,
well, actually, I'd like to take the opportunity to introduce Wade Beltramo.
Okay.
Because we advertised this panel as a panel, which means multiple speakers. However, I was unsuccessful. My mea culpa is getting anybody from the Cannabis Control Board to participate in the panel. So I'm just the idiot that fills out the extra role in the panel discussion here. But this will be the Wade Beltramo show, and we're so pleased to have Wade here. He's for many years been general counsel at NICOM, where he's responsible for general municipal legal matters, as well as building code, property maintenance, and community and economic development, as well as local government consolidation and dissolution issues. Prior to joining NICOM in 2002, he served in New York City as assistant corporation counsel. And he graduated from Grinnell College and has a JD from Brooklyn Law. And his daughter is going to Italy on a study abroad semester coming up next year. So he's excited about that. So without any further ado,
not a semester, a whole year. She's going a whole year.
Amazing.
Yeah,
it's amazing.
August to June. Hopefully she'll be fluent by then. That's what it takes. This was going to be a panel. We were going to get somebody maybe from the Office of Cannabis Management. I will say they're busy, and also I'm not sure what information they would provide. So I put that caveat out there. As we go along, please use the Q&A box. If you have any questions, I'd be more than happy to answer those to the extent I can. I've included a copy of the PowerPoint in the chat box. Hopefully it came up to everybody, and if not, then I will include it again at the end. It's a slide deck handout for today's presentation. So let's get going. This is not the first time I've presented on the topic of the law, the cannabis in New York. And from the very first presentation I gave back on April 15th of 2021, the theme of the presentation was TBD, still to be determined. And we are still there here in June 2022. And that is really because we are waiting on, and I will delve into this more as I speak today, the Office of Cannabis Management, the Cannabis Control Board, to adopt their regulations, to even promulgate them so that we can see what they look like. Having said that, things are happening, things are moving. There was a bit of delay in the forming of the Cannabis Control Board. There was a disagreement between Governor Cuomo and the legislature last summer that resulted in a lag in appointments being made to the Cannabis Control Board. That resulted in a delay in them hiring staff and starting the process of promulgating regulations. And so they got a late start, and they are working as fast as they can to implement the legalization of adult use cannabis in the state of New York right now. But we have a ways to go, and I will flesh that out as we go along. The focus of today's presentation is really about local government regulation of cannabis business from the perspective of really land use regulations. And if we think about this, we really need to, people need to understand the types of regulations that are at play with respect to cannabis operations. There is the New York State Cannabis Law. It's a new law that was enacted as part of the MRTA. And then local governments still have their local regulation, which is going to be predominantly zoning or land use regulation. I say predominantly because issues of consumption, so smoking, definitely are a concern for communities across the state. And that is an entirely separate area of law that's not really considered land use regulation or zoning regulation in that context, to the extent that communities have adopted or are thinking about adopting public consumption laws. They're really going to be separate and apart from land use or zoning regulations. I do not have a sample local law regulating cannabis businesses. We get this call all the time. Would you have a sample? And my response is no, I don't have a sample, because local zoning regulations, land use regulations, are local creatures, as you're all aware. They are different. They vary what types of regulations communities have put in place. Some use special use permits, others do not. Some are very detailed and restrictive, others are not. And so there's no real model or sample local law for regulating cannabis businesses. It just doesn't exist in the first part. The second place is that I don't know what the Cannabis Control Board is going to issue as far as its regulation. So It's a little bit difficult for me at this point to kind of provide a model, but I do have some suggestions or recommendations about what communities should be doing. I will say, up until about 3 months ago, I was telling my members, my city and village members, to wait a second, don't adopt anything at this point. Wait for the Cannabis Control Board to promulgate their regulations, at least put out the draft regulations so you can see where they're going, and then start crafting your regulations accordingly. However, the CCB is moving forward. They are moving rapidly with respect to the citing of what are referred to as conditional adult use retail licenses. And I'll talk a little bit about that. So there is some urgency on the part of local government officials at this point to kind of be focused on the issue. And again, hopefully I have some good advice as far as what you should be thinking about. But let's start a little bit with an overview of the law. The law was enacted back in 2001. It's Chapter 92 of the laws of 2001. It's known as the MRTA, or sometimes people pronounce it MRTA. I should note that this law was around for a long time. This was not something that was enacted at the last minute. The original proposal to legalize adult use cannabis in the state of New York was introduced in the legislature in 2013 by Assemblymember Peoples-Stokes and Senator Kruger. And it took them 8 years to get this adopted. It was in the governor's budget, proposed budget, starting back in 2019. And so it had started to get a fair amount of attention that long ago. It just took them some time to actually enact it. It went into effect. It was signed into law on March 31st of 2021, and it legalized the possession and use of cannabis immediately. So right now, individuals can use and possess cannabis. Sales are not legal yet, and I'll talk about that in a second. I think it's important for everybody to understand what the purposes of the MRTA are when kind of fleshing out their approach when adopting local regulations. And there are two overarching categories of purposes. One is to create a regulated and taxed cannabis industry in New York. And this may come as a shock or surprise to some of you, but for a long, long time, we've had an unregulated and untaxed cannabis industry in New York. We still have that right now because, again, we don't have sales, or at least legal sales, authorized yet in New York. A second component of the law, second purpose or overarching purpose of the law, was to provide social and economic justice related to the sale and use of cannabis. And by that I mean, if you look at the history of regulating cannabis, of criminal prosecutions of cannabis sales and use, even though white communities and communities of color used and sold cannabis at the same rates, the communities of color were disproportionately impacted by the war on drugs. They were incarcerated at a higher rate than white individuals. Even again, though there was the same level of use and sale. And so one of the goals of the law is to kind of right those past wrongs. And both the Cannabis Control Board and the Office of Cannabis Management is acutely aware they do not want to have decades of inequitable criminal enforcement against Black communities, Latino communities, and then all of a sudden create this new market that a lot of rich white people come in and make a lot of money off of. So that is part of their goal. And to that extent, they have expunged the law. The law included expungement of criminal records for past, not all past cannabis violations, but a vast majority of possession and use and sale violations. As I mentioned, the possession and use has been legalized immediately. I think at this point, the actual sale of adult use cannabis, we may see by late 2022, maybe not. It's, it's June now. We still have a lot of things to get in place. And I'll talk a little bit, they're working very hard though to start this as quickly as possible. So That's the earliest we're going to see any sales. I wouldn't be surprised if the first sales actually don't start until 2023 at some point. And I should note also that, Massachusetts has legalized cannabis. New Jersey just had its first legal sale of adult use cannabis a couple of months ago. And so, part of the urgency on the part of the state is like to establish the market here in New York. One of the things to know too is the MRTA, the Marijuana Regulation and Taxation Act, is what that stands for. I should have said that earlier. It created this new cannabis law, which is known as Chapter 7A of the laws of the state of New York. And it covers all things. It covers medical use, it covers hemp growing, it covers adult use cannabis. It also substantially amended many other provisions of state law, including the penal law, the public health law, the tax law. So there are many components to that, and I will upload also another summary of the law in a second here. The MRTA, I've already mentioned these a couple of times. It created two state agencies, the Cannabis Control Board and the Office of Cannabis Management, and you can find their website at cannabis.ny.gov. They are pretty good about, you can sign up for notifications. They have a lot of information they're putting out. Their meetings are being streamed online. You can stay abreast of what they're doing relatively easily by going to that website, cannabis.ny.gov. But what they still need to do, they still need to promulgate a lot of rules and regulations governing the licensing and operations of cannabis businesses. And these are the types of licenses that they can issue. Any business engaging in cultivation, processing, distribution, delivery, cannabis dispensaries, the retail dispensaries, or operating as a cooperative or micro business or nursery or an on-site consumption establishment. Those are the types of businesses that are identified in the MRTA. Okay. So with that said, and it's important, I'll come back to the screen at least one more time during the presentation. These types of entities are not all treated the same, and you'll see this very quickly here. But before I go to those licensing, I talked about legalization. Penal Law Article 222 governs cannabis. Use and possession and purchasing is only going to be allowed by individuals who are 21 years and older. They may possess at any given time up to 3 ounces of cannabis or 24 grams of concentrated cannabis. Again, this does legalize consumption and the possession and sale and purchase of paraphernalia in that context. And I just had an email inquiry from one of my members just last week about paraphernalia and whether or not they could prohibit the sale of it. And I think the way it's not 100% necessarily clear in section 222.05 of the New York State Penal Law that states that paraphernalia is legal to purchase, whether or not a municipality could prohibit it sale from its jurisdiction. I'm inclined to think that paraphernalia sales cannot be prohibited by local governments. It's a retail item, and the state has basically preempted the field, in my opinion, with respect to all things cannabis. And so local governments need to tread carefully when adopting regulations regarding cannabis and paraphernalia. With that said, there are basically 4 types of regulations that local governments really need to be focused on at this point. And one of these is the local opt-out. That has really run, but I'm going to cover it anyway because in a second, because communities that have opted out can repeal that opt-out now. You can no longer opt out. That ship has sailed. But if a community has opted out back in 2021, they can repeal that to allow retail dispensaries or on-site consumption establishments to locate and operate within their jurisdiction. And you will note here that the opt-out only applies to retail dispensaries or on-site consumption establishments. So those other types of activities, cultivation, processing, distribution, delivery, those all can occur within a municipality. You cannot opt out of allowing those types of cannabis businesses to operate within your community. So that's the first type of local regulation. The second type of local regulations are regulations involving retail dispensaries and on-site consumption establishments. And here, Cannabis Law Section 131 provides in relevant part that local governments may adopt time, place, and manner regulations of retail dispensaries and or on-site consumption establishments that do not make their operation unreasonably impracticable as determined by the CCB. I'm going to come back to this in a second, but this is an area where, you know, we're really waiting for the Cannabis Control Board to offer guidance in their regulations. And I have been in touch with CCB on this. I've offered them some suggestions about how to craft regulations to help local governments, and I'll talk about those in a little bit. I will note here, and it won't be the first time that I note this today, that this is weird language. It's unusual language to include time, place, and manner when discussing land use regulations. If we have any attorneys on today, time, place, and manner, they're probably familiar with that from First Amendment jurisprudence. That is language that we use when talking about the rights of individuals under the First Amendment and freedom of expression cases. It is not a terminology that is regularly used in land use regulations or jurisprudence. It's not really relevant to zoning by its nature, and so that's a challenge. And I'll talk a little bit more about that in a second. So again, but we have this specific language, this time, place, and manner regulation language that applies only to retail dispensaries and on-site consumption establishments. And these are locations where adult use cannabis can be sold. All right. So with respect to all of the other types of cannabis businesses, they're going to be subject just to our normal land use regulations or land use authority, whether it's zoning or whether it's another type of land use regulation that's short of zoning, cultivation operations, distributions, nurseries, delivery services, processing entities or businesses. They're going to be subject to your normal traditional land use regulations. And then finally, public consumption of cannabis. Article 13-E of the Public Health Law, which many people know, originally was a Clean Indoor Air Act. It was amended to be just a Clean Air Act, was adopted back in the 90s, right? I mean, that's how long it's been on the books, that prohibited smoking in most indoor facilities that were open to the public, including restaurants and what have you, offices as well. This law was amended to include cannabis to that restriction. One of the things to note, though, is that under Article 13E, local governments are expressly authorized to adopt further, more restrictive regulations with respect to the smoking or vaping of tobacco or cannabis. And that's another area where I think we're going to see a lot of interest from local governments in adopting regulations. Again, we wouldn't consider these necessarily land use regulations. It's more just general regulations, but I have seen quite a few communities that are adopting regulations prohibiting smoking in public parks, on playgrounds, on sidewalks or streets. And that is an area that local governments can engage in. It's totally acceptable. Very quickly, the local opt-out. There was a local opt-out provision. I say it was. It's still on the books, but it was only effective through December 31st, 2021. A city, village, or town had to adopt a local law subject to a permissive referendum on or before December 31st, 2021, opting out of allowing retail cannabis dispensaries and or on-site consumption establishments from locating within their jurisdictions. If they didn't opt out by December 31st, 2021, too bad, so sad. It's too late now. It's kind of a one-way street. Many local governments, however, did opt out because they wanted to kind of have a wait and see approach. What is cannabis going to look like? What are the regulations going to be? What's going to go on here? So they wanted, if you didn't opt out, you lost the opportunity. And so we've seen quite a few communities that just opted out from an abundance of caution. And they can repeal those opt-outs at any time if they decide that they want to have a retail dispensary and or non-site consumption establishment within their jurisdiction. So that is an option. I just want to put it out there. I will note that any local laws that were adopted prior to the enactment of the MRTA on March 31st, 2021, and we did have quite a few communities that adopted cannabis prohibitions prior to when the MRTA was adopted. Those laws, don't have any effect. They're not effective. Turning now to the general regulatory authority of local governments. Section 131 of the cannabis law specifically prohibits and preempts local governments from adopting any regulation regarding the operation or licensure of registered organizations or licensees. Okay, so what does that mean exactly? Does that mean that those types of entities are exempt from your local land use regulation? No, that's not what that means. But what it does mean is that you may not, require a license to operate within the municipality. And as far as operation, the line between what is going to be acceptable and unacceptable operations is really, I think, going to come down to what the CCB says in its own regulations. I will note this too. I have a lot of communities that are really concerned. They're concerned about the unknown. What does this look like? I've had some officials who are afraid people are going to go and they're going to purchase cannabis, and then they're just going to go out in the parking lot and they're going to light up and they're going to get high right there in the parking lot. I can't stress this enough. If you are a community where you think you're going to have a retail dispensary locate within your jurisdiction or other type of operation, a cultivation operation, go visit Massachusetts. Go visit New Jersey and see what they look like. I think it's my understanding that the operations in Massachusetts for retail dispensaries, that's very similar to what we're going to have here in the state of New York. So by that I mean the signage is going to be heavily regulated by the Cannabis Control Board. It's not going to be, in fact, these stores are going to be nicer than any kind of liquor store or gas station in your community. The windows are going to be frosted, I assume. I think that's probably going to be a regulation so that minors can't see into the stores. And it creates for a very unobtrusive establishment within the municipalities. And one of the communities I think you can see the whole kind of variety of cannabis operations is Northampton, Massachusetts, where they have several dispensaries right in downtown historic Northampton, Massachusetts, and then they've got others that are kind of more in a strip mall area. And I think if this is an issue of real concern for your community, that it behooves you to take a day trip out to Massachusetts and just visit the operations, see how they operate. Same thing with respect to the cultivation operations. There is a ton of security that's mandated by the state in Massachusetts, and I think is going to similarly be mandated here in New York. That security is required to ensure that there is no diversion, and that's the technical term that they generally use in the industry, that the legally grown cannabis only finds its way into the hands of adults who are authorized to purchase and use and possess cannabis, so that it doesn't find its way into the hands of underage individuals. I will tell you the tracking. I've gone on site visits in Massachusetts. They track everything. They weigh everything. It's accounted for. It's tested multiple times. It is a highly, highly regulated business. And I think it's just, I've been working on this issue for a long time, and going and visiting was a whole other level of knowledge that I was able to get. I have a quick question here. If a community that opted out wants to opt in, are they still subject to the permissive referendum requirement? So that's a great question from an anonymous attendee. And my answer to you is, as a general rule, we at the Conference of Mayors advise that there is what is known as the principle of legislative equivalency. And what that means is, however you enact a regulation, you need to follow the same procedure to repeal or amend it. One of the things I will note, however, is there is an opinion from the Attorney General's office that states, and there may be a court case too, I can't remember off the top of my head, that basically states that no, unless the law specifically states that repeal is subject to a permissive referendum, and this law does not, then it can be repealed simply by a local law that would not be subject to a permissive referendum. So I be careful. You know, if I were offering kind of the most conservative approach, I would say, hey, you might want to consider, just following the permissive referendum time period of allowing somebody to circulate and submit a petition, but consult with your attorney. So the state has issued this preemption language here with respect to operation and licensure, and New York is going to heavily regulate cannabis operations, all of the different types of operations, from where they're going to impose their own regulations regarding location. They're going to put in place regulations regarding signage, regulations regarding hours of operation. The state is going to have its entire panoply of regulations. And so, local governments kind of do need to wait and see what those look like. Having said that, let's take a look at what you will be able to do and what I think you should be focusing on, at least at this point, of starting to kind of review your own existing land use regulations and formulating kind of like a response or maybe some amendments to that to address cannabis coming down the pike. The first thing we're going to focus here in is adult use retail dispensaries and on-site consumption establishments, again, because they have this special language about time, place, and manner restrictions. I don't know what that means. The state put this in place. I think we're really going to have to wait here and see what the Cannabis Control Board states with respect to what they deem to be unreasonably impracticable. From day one, I have been advising communities to think about and treat retail dispensaries like liquor stores, to think of and treat on-site consumption establishments as bars in that respect. And I think local governments need to be very cautious about imposing regulations on cannabis retail dispensaries that are more onerous or restrictive than regulations on a liquor store or on an on-site consumption establishment that are more onerous than a bar. And the reason being is, if we think about this, first of all, the state has made the possession, use, sale, purchase of cannabis legal to individuals 21 years and older. Well, that's the same for alcohol, right? The state has evidenced a substantial interest in legalizing this industry. And to the extent, if you didn't opt out at this point, putting in more restrictions that are more onerous on retail dispensaries than are on a liquor store, or more restrictions on an on-site consumption establishment that are more onerous than a bar, I think raises the red flag. Why? What is the justification? What is the rationale from the local government to treat these types of operations differently? So very quickly here, I should also note that if you look at the time, place, and manner language, we only see this in 3 other states. Alaska, Illinois, and Massachusetts have also adopted time, place, and manner regulation authority in their state charter, in their state codes. Having said that, there isn't any case law really interpreting these provisions. What does time, place, and manner mean in that context? So we, as we go on, we'll be looking for case law in New York, but we'll also be looking for any court decisions in any of these other states interpreting what this means, what's a reasonable time, place, and manner restriction in that respect. Very quickly, before I go on to discuss this case, because I think this case is very helpful for communities, I do have a question in the Q&A box. With the clarification that a municipality cannot require registration and licensure because of New York State preemption, does this also apply to adult use establishments? It applies to everybody. It applies to everybody, right? I mean, by that, I mean, it applies to all of the different types of licensed operations: cultivation, processing, distribution, delivery, on-site consumption establishments, retail dispensaries, cooperatives, nurseries, micro businesses. That language regarding the operation and licensure applies to all of those types of businesses. Having said that, like, clearly, and this is, I've had discussions with the governor's office before this was adopted, and with officials from the Cannabis Control Board and the Office of Cannabis Management. You know, clearly it's not their intent that that language should be read or interpreted as exempting cannabis operations from local land use requirements. For example, I mean, it's there. The law is not going to be interpreted in a way to allow a retail dispensary to go into a residential neighborhood, or a cultivation operation to go into a residential neighborhood, right? If it's not in the zoning, it's still going to be subject to zoning. But I think this is a good segue to this case. Now, this case came down just last summer in Massachusetts. So I'll note this isn't binding. Adult use in the context meaning of sexual oriented uses. No, I don't think so, Molly. I think the issue there, I see what you're saying. No. I wouldn't analogize. I think the analogy to use at the local government level, and this is what I'm encouraging and have been from day one, is for local governments to think about and treat retail dispensaries like liquor stores and on-site consumption establishments like bars. I think that's the way to go, right? You know, with that in mind, let's look at this case, right? Town Planning Board. In this case, the Town Planning Board concluded that a proposed marijuana establishment constituted light manufacturing, and this was a grow facility, right? It wasn't a retail dispensary that was the issue here. It was a grow facility, and they interpreted it as being light manufacturing, and therefore it was not allowed in an agricultural or commercial business district per their law in that context. The trial court judge concluded and declared that the proposed use was an indoor commercial horticultural / floricultural establishment, for example, a greenhouse, and as such was a use allowed by right, that it was not light manufacturing, that it was allowed by right in agricultural and commercial business districts. And the judge found further that cannabis would be grown hydroponically without chemical pesticides in closed greenhouses that would carefully maintain environmental conditions, filter air contaminants, and mitigate odors. Post-harvest processing would include separating cannabis plants. And I will note, in Massachusetts, a little bit different. In Massachusetts, their operations can be vertically integrated, and there are places where they grow their own plants, they then process them there, and by that I mean they'll dry them, they will take off the buds and put them for sale, or put them in make pre-rolls, They will then also extract the oils and concentrated cannabis, and they'll sell that, but they'll also put that into edibles and things of that nature. And they will all do that in the same establishment.
So Wade, to that effect, when they're doing their vertical integration, it sounds like they're doing the packaging, and they're handling more than simply.
Not all of them, but many of the growers do more than just grow.
Right. I'm thinking of the differentiation between, let's say, a nursery or an organization or a business that develops that takes that nursery output as an input for another product and then manufactures.
Correct. Right. And that is going to be very different here in New York. We're not going to have vertical integration, at least not yet, at least not now. Our structure is set up that the businesses cannot be vertically integrated. So you're going to have growers who then sell their product to a processor who's then going to process it and then sell it to a distributor who's going to sell it to the various retailers. And so you're going to have separate businesses located in different locations. Now they could be really close. They could be right next to each other. I wouldn't be surprised if we see that, but from a licensing standpoint, it's not going to be one entity.
Wait, I guess I'm asking for you to put on, like, look into your crystal ball. That's kind of how alcohol sales was prior to legislation that allowed the expansion or operation of breweries to be able to serve food, to be able to be the bottling, the distribution, and a consumption site. Do you see at some point in the future the New York State allowing? And then it's way too much of a forecast, but at some point in time,
I don't know. You know, it's so funny. We have one of the benefits. We are not trailblazing here in New York, right? I mean, we're not. There are many other states that have legalized way ahead of us. Like, you know, California, huge markets, Colorado, Oregon, Massachusetts had their first legal sale in November of 2018, right? So we're many years behind them. And so what they've tried to do, and I think to a certain degree, they're trying to avoid mistakes made by other states. With that said, even in Massachusetts was not an early adopter, right? I mean, again, they had their first legal sale in 2018, which was a long time after Colorado, which was 2011, I think, right? First legal sale in Colorado. And Massachusetts right now is in a terrible place because they have oversaturation of the market. I mean, the market fell out in Massachusetts the fourth quarter of 2021, and businesses are really struggling. And one of the things New York wants to do, I mean, there are many issues that they're cognizant of, is they want to make sure that the business is viable here, that we don't have a boom and bust cycle, that we don't have a lot of people coming in and pouring money in, and then production of too much cannabis, which has happened in other states where they produce tons and tons and tons. And when I say ton, that is a lot of cannabis, tons and tons and tons of cannabis, way more than what people could sell. And then what do you do with that? Because that will find its way, you know, you have to be careful. It has found its way into illicit or gray markets, whatever you want to call it, right? So it will. Is it possible that, you know, a few years down the road, the law is changed and allows for your example, I think, is a great example, you know, microbreweries to not only create their own beer and then sell it and do that here in New York, perhaps, but not at the outset. I don't see that. Molly, you asked about what micro businesses. Now, micro businesses, and I will tell you this, it was put in the law. Whether we actually see that come to fruition, I don't know. Micro businesses, in part, were designed and intended to be for smaller businesses, firms, individuals to get a license to do any of the other types of activities. You know, really with the goal and objective of being accessible to communities or individuals who were negatively impacted, again, by the war on drugs and don't have $500,000, $1 million to get into the business. And it is very expensive. It is very expensive to get into the cannabis business. You know, the startup costs are huge. And because of cannabis is still legal at the federal level, it's still a Schedule I drug. There are restrictions on banking. it is very costly for local governments to be in the cannabis business. There is something referred to as 280E, which is a tax provision that's very onerous on cannabis businesses. And they don't get to write off expenses. And it's just very difficult. So micro businesses in theory are designed for those individuals, but how that plays out, I don't know. And I'll talk about one of the tacks that the state is taking to kind of address this issue at the outset is this conditional adult use retail license. We have another question here very quickly. Due to the lack of information available, there's a lot of uncertainty regarding whether local authority begins and ends. I've read that DASNY will be involved and that yes, DASNY is working on that. I'm going to come back to this in a second. So we'll keep that question, Matt, and hopefully I'll answer some of your questions about that, right, in a second. So let's finish up this case. The judge found in this case that cannabis would be grown hydroponically. Like it was basically a greenhouse is what it was. Now they did do processing there. And so to the extent they're like, well, it wasn't just a greenhouse. The court stated though, basically looking at this is that within the meaning of the statute, what they were doing was really an agricultural use. And that the post-harvest processing activity, which accounted for only 13% of the site. And generally when you do have these kind of integrated facilities, a vast percentage of the site is comprised of the greenhouse, right? It just takes a lot of space to grow these plants under these lights. That was kind of an accessory or ancillary use, and as such, still was considered agricultural. Now, one of the things I want to point out here, and this is a difference too in Massachusetts. So we can learn lessons from Massachusetts, but it's not 100% analogous. And that's because in Massachusetts, they allow both local land use regulations, but they also allow for and provide for community host agreements, which we don't have here in New York. There are no community host agreements. And I think there's some pros and cons to that. The community host agreements were, many of the communities are getting kind of in trouble because they put in place some community host agreements and really kind of exacted these huge financial aspects or financial penalties, I'll say. They're not penalties. Compensation from these operations as a condition of agreeing to the community host agreement. And they also could get impact fees. We don't have impact fees in the state of New York. So that's another important difference. But what they did here in this Massachusetts case, because the town did not enact any ordinances placing reasonable time, place, or manner restrictions on the marijuana establishments prior to the time that the operator and the owner submitted their preliminary subdivision plan, and thereby froze the zoning, the judge reasonably looked to the zoning bylaw as it existed when the preliminary plan was submitted to determine whether the VGG's proposed use was permitted as of right. The question for the judge and the question addressed by the planning board, therefore, was whether the project met the definition of agriculture or horticulture in the town's bylaws. And I think this is the key takeaway, and this is what I'm encouraging everybody to do, is to go through your own local land use regulations right now and say, hey, for cultivation operations, where do we allow greenhouses within our city, village, town? Right? Treat cultivation operations like a greenhouse, like a horticultural or floricultural use. For processing, where do we allow like light processing to be done? And it really is light processing. You'll look and see that it is a bit of like a chemistry lab from high school or college, where they're working and distilling the cannabis concentrate from the plant material that they then they sell, or that they then use in other products, such as candies, edibles, what have you. For distribution facilities, like, we allow distribution facilities in our C1 zone. Well, that's where a cannabis distribution facility is going to be allowed as well. It's not going to be any different than any other type of distribution facility. And then when we get to retail dispensaries, I really think that is a retail. It's in the name. It's a retail dispensary. So where do you allow retail uses? And in particular, if you allow liquor stores in some location, I think the onus of burden is really going to be on the municipality to justify not allowing cannabis operations to be in the same district. Okay. Same thing for on-site consumption establishments. So that's what you really should be looking at this point is going through your zoning code, your land use regulations to see where you allow those types of analogous uses at this point. One of the things that I'm going to skip here that's important, and this is something that all hopefully members of a planning board and ZBA need to understand. These were some of the factors that the planning board said, hey, made this facility light manufacturing and not a cultivation operation, not a greenhouse. It was how much water they use, the number of employees or whatever. And the court said, though, that the planning board failed to explain how those factors rendered it a use light manufacturing rather than commercial horticultural. And they noted there that there are many, many greenhouses and agricultural kind of operations that use a ton of water and have a lot of employees and have trucks coming in and out. So they didn't really distinguish. The planning board did not sufficiently distinguish the operations as light manufacturing compared to other similar types of agricultural operations. So one of the things finally here that I'll note is that there's no the land use regulations that the town had in place expressly allowed for indoor commercial horticultural uses and contain no limits on the size of any allowed commercial greenhouse or accessory structure. And in essence, the town got hoisted on its own petard. Like the court said, hey, you've made these regulations, you got to live by them. You've made these regulations, you've got to live by them. So with that said, one of the things that I will note is that there is conditional adult use retail dispensaries. These are regulations that are allowed for or intended for individuals who were injured by the war on drugs. They themselves were either incarcerated or had a criminal record for certain violations of cannabis use or possession, or their parent, they're a child of somebody who spends time in jail. Those individuals are going to be able to get a conditional adult use retail dispensary. Now, the CCB published these regulations, proposed regulations back on March 30th of 2022. Comments were could be submitted through May 31st. They are now in the comment review period where the CCB is going to review and respond to all the comments that were made, and then they will finalize these regulations sometime, probably if I had to guess, late July, maybe August, at which point these regulations will be finalized, and then they will start issuing these licenses. They will start accepting applications for conditional adult use retail dispensary licenses, and they will issue those. Those licensees are then going to have an opportunity, and Matt, to your point in the Q&A, you talked about DASNY. Now, DASNY is currently going through and looking to set up approximately about 100 sites to enter into agreements where DASNY will enter into a lease for the operation of a conditional adult use retail dispensary license. And I didn't know they were doing this until they issued a report, I think in March at the CCB meeting. And I'm like, wait, what are they doing? They're going around and they're identifying locations to have these dispensaries. This is the first I'm ever hearing this, and I'm kind of on top of this issue. And what they're intending to do is create turnkey sites that are offered to the first catered, I don't know what they're called, licensees, right? And so that these individuals who don't probably have all the resources that are necessary to get a retail dispensary up and running will be able to actually, go into one of these sites and start operating relatively quickly. Now, the CCB has stated their goal. They want to have the first sales by the end of 2022. I am skeptical that we will be at that point. I could be wrong. It's a very quick time frame. But having said that, DASNY right now is going throughout the state. They're doing site visits. They have preliminary, like over 450 sites that have been kind of identified, and they're going through and conducting site visits, and they're going to enter into about 100 leases that are going to be offered to these licensees to get them up and running, and both to give them the kind of the first bite at the apple, to give these individuals who don't necessarily have all the resources that the big companies have. And I mean big companies. There are big companies involved here. I mean, New York is going to be the second largest market in the country. And so there's a lot of money at play. But to give these businesses the advantage of being the first kind of operation for at least probably the first 6 to 12 months in the state of New York. So that's where we're at with respect to these. I want to go back because Matt had the question, and he talked about, the Dormitory Authority will deliver a range of services in relation to the fund, including but not limited to identifying and acquiring and leasing retail dispensary locations. That's what they're doing right now. Designing, constructing, and renovating locations as adult use cannabis dispensaries, again, what they're intending to do right now, and outfitting locations with furniture and other equipment as needed to operate the establishments. The question here, and I think this is a great question, since localities have limited jurisdiction over the zoning regulation of state-owned property, we are wondering how the role of DASNY will affect our local authority. Is the role of DASNY similar to how other states have handled the rollout? Well, the first thing I will tell you is no, the role of DASNY is not how other states have done this, because no other states have tried to address this equity issue, and they've failed miserably. All right. I mean, nobody's really done a good job of addressing the equity issue. Instead, the money's all gone to big firms, and it's mostly white people, and the people of color who were, again, victimized by the war on drugs, the war on cannabis, have been, left out. They've not had an opportunity. So this is really kind of innovative, and I do give the state a lot of credit for that, because I think that's what had to be done. It is a very running these businesses is complicated. There is a lot that has to be complied with. There's a ton of accountability. It is not for the faint of heart. Opening a business under the best of circumstances is a challenge. Opening a business that is highly regulated and still subject to federal prohibition and all of the problems that creates, it's exponentially more difficult. So, to their credit, I think this is good for DASNY, good for the state. The comment about, are they subject to local regulations? So I put this to OCM, and just saying, hey, technically DASNY is a state agency. The question about whether or not they're subject to local land use regulations, I mean, for the most part, one would think that no, they're exempt unless they're going to agree to this. The other thing I asked them, I'm like, when you're going out here and identifying these places, are you doing this in consultation with the local officials? And the answer to that was not at this point, but they intend to later. So I actually have had several communities come to me and say, hey, we are interested. We have a place that we would be more than happy for DASNY to look at. So, it can go both ways, that if you have a community that is interested in this, I can put you in touch with DASNY. I can put you in touch with OCM, and they can put you on the list of having a site visit. So
yeah, but wait, it seems like they're involved in like startup. They're not going to hold title to the facility, right? I mean, they're just looking at providing assistance to a startup, and then once it gets off the ground, it's not going to be a state agency holding the land and leasing it to an entity. Is that Is that what DASNY is
Oh,
proposing?
I think they're going to keep it. I don't think they're going to.
Wow.
They are going to enter into the lease.
Wow.
It is
Okay.
DASNY that is going to hold the lease, and I don't think there's going to be a transfer of the lease for a variety of reasons, right?
Huh.
I mean, part of the challenge is, these CADURD, I don't even know what they're calling it. I don't know how to pronounce it. These CADURD licensees, they do as a general rule. Now many of them may have a lot of business acumen. We'll see who gets awarded one of these licenses, right? But the whole purpose is to give these to people who were, disadvantaged. And I can tell you, it is a whole other level of business operation running a cannabis business. There is money to be made, absolutely, but it is logistically, it is a huge issue. And so that's a challenge. That's a challenge.
One of the things I'm curious about is for local municipalities, let's use Albany as a case study, because we have a lot of state enterprises here which are exempt from the tax rolls. It seems like we're going to be, thrust upon land use like this without being able to see any property tax benefit if the state comes in and sets up shop.
Yeah, I don't. That's a great question. So to the extent, I mean, one of the issues there, I think in that respect, I'm not sure DASNY is looking to take the property off of the tax roll. That's a great question, and I do not know. I mean, we at the Conference of Mayors are painfully familiar with tax exempt properties and the harm it causes to local governments and the surrounding community, the other taxpayers. I don't think that's, I mean, there's only going to be like 100 of these spread across the state. So it's not going to be like it's a huge impact on any one municipality. If you figure that of these 100 types of operations, maybe a quarter plus are going to be in New York City. I would be surprised if it's more. And then in other locations. I mean, when you start putting them around the state, it's not that many in various jurisdictions. So this is the first 100 dispensaries. And I say that 100, I'm not sure, they don't have a hard and fast number. So don't go out there. I think there's a kind of a ballpark figure that they're looking at. I think it depends on a variety of factors. And if anybody tells you anything about numbers, like, so for example, how many dispensaries are they going to license? They don't know. They're gonna go slow and steady and figure out what the market should be. They don't know what the market is. They don't want to have too many. They don't want to have not enough. So it's going to be probably several years of issuing licenses that are geographically distributed throughout the state and kind of like seeing where there need to be more dispensaries and how much of a market there is in each region in that respect. So that's these first regulations, right? These conditional adult use retail dispensaries. They actually issued, or I shouldn't say issued, they promulgated or issued proposed regulations last week regarding the sale and packaging, because that's a huge issue also in other states, to make sure that the packaging is not attractive to minors, that it's not something that looks like something a kid would want. That's a huge issue in Massachusetts. That's going to be a huge issue here in New York. There are going to be a ton of regulations regarding advertising and marketing, signage, that are going to take a lot of the issues out of the hands of local governments. Those regulations are going to be so restrictive that I think most concerns of local government officials, it's going to be addressed by the state regulation again. But when are we going to see those, right? So, God, it's already 2. Let me go. This is only supposed to be an hour. I'm almost to the end, but I do want to cover a couple of other things. The full regulations, at this point, I think they're going to be published, the proposed regulations, probably not until July, maybe not until August. They will then have a 60-day comment period. I think once we get the proposed regulations, even if they amend them afterwards, even if they make some changes, at that point, it will give us a pretty good feeling or understanding about what they are going to be in their final form. And at that point, communities can really hit the ground running. But before that, again, you really need to be going through your land use regulations to see, what does it look like? Where would a cultivation operation be allowed within our jurisdiction? Where would a retail dispensary be allowed within our jurisdiction, given our current zoning land use regulations? The final regulations, finalized regulations, I don't see until late 2022, maybe not even until early 2023 for that matter. So if we look down, and this is just an overview here, right? We have these different types of operations where individuals and organizations must obtain licenses, and you have the ones that are just going to be subject to kind of general land use regulations. And then we have the retail dispensaries and the on-site consumption establishments that are subject to the time, place, and manner regulations. If we were to do a Venn diagram, this is what it would be like. But again, I don't know exactly what those time, place, and manner regulations look like, and won't really until we get some more guidance from the CCB. One of the things I will tell you is that I think they are not going to be they're not excited about the prospect of special use permits. So to the extent that communities were thinking of regulating cannabis operations via special use permit, I think there's a ton of skepticism on the part of the Office of Cannabis Management. And part of that has to do with, I think, the level of discretion that are found in many SUP programs, right? If you look at, and you could go through special use permit regulations, and some of them are very detailed about what factors will be considered, and a lot are not. A lot are very discretionary. I wouldn't be surprised if CCB issues regulations that in the regulations, they analogize retail dispensaries to liquor stores and basically say, hey, if there is a rebuttable presumption that a retail dispensary should be allowed in any location where a municipality allows liquor stores. And if you want to enact a more restrictive standard, then you might need to apply to the CCB for a more restrictive standard. We could see something like that. I'm not sure. So that's why you want to go through. You want to go through your zoning. You want to make sure that wherever similar types of operations are allowed in your community, that if you have non-cannabis uses allowed in one area, that cannabis uses of a similar nature be allowed in those same jurisdictions. That's what you should be looking for at your zoning with right now, in my opinion, to get kind of a leg up on this. And again, I mentioned special use permits. I think they're going to be very skeptical. I'm not sure they're going to come out and say special use permits are not allowed, but from my discussions with the Office of Cannabis Management, they're very skeptical about SUPs. So with that, the last slide, this is my very last slide, and this is something, we have short-term issues and long-term issues. And by that, I mean, the long-term for cannabis is like 10 or 15 years from now. I was watching a show recently, and they mentioned, it was a fictional show, but they made some comment about how after prohibition ended, alcoholic prohibition in the United States ended, the alcohol market didn't really get up and running to its full market potential for like 10 years. And so if you think about this, that's what we're looking at here. Cannabis has been legally sold in Massachusetts now for 3.5 years. Their estimates are that 50 to 75% of the sales in Massachusetts right now are still illicit or in the gray market, right? So meaning that only 25 to 50% of current cannabis sales in Massachusetts are occurring via legal markets. So what do you think about? What are the issues that we need to think about in the transition? First of all, the first dispensaries are going to have huge demand and limited supply, right? And what did we see in other states? We saw traffic issues with that, parking issues with that, pedestrian lines. I definitely think that local governments can put in regulations requiring traffic plans, parking plans, pedestrian management plans, or things of that nature, to the extent that those are potential issues in whatever areas, right? You will notice still, if you go over to Northampton, they have, I think, 8 dispensaries in Northampton right now, this one city in Massachusetts. And in some areas, there's no problems. Traffic parking's not an issue. But the dispensary that's right off the interstate, they still have a cop there, like most of the time, dealing with traffic because people are just hopping off the interstate to buy their cannabis, whether they're hopping off from other parts of Massachusetts or whether or not they're driving up for the weekend in New Hampshire or Vermont. It's a huge amount of business. And that's something that communities are going to need to think about. And so even beyond this transition period where we rev up the demand, what if you're a community that's on the border, say, with Pennsylvania? You know, your Binghamton, your Oneonta, your Binghamton, your Olean, your Jamestown over on the southern border. You should expect a fair amount of traffic where people are just driving over to get cannabis from New York. And so those issues need to be addressed and thought about as well. And maybe in a way that's it could be related to your land use or zoning, but I also think that you can adopt separate kind of transitional regulations with respect to cannabis in that respect. So that's my last slide. I'll answer questions here. Dahlia, it appears New York State permits growth of plant for personal consumption. It does. There are two types. If you're a medical user, they promulgated regulations. You can actually do homegrown right now. Pursuant to state regulations, they limit the number of plants that you can grow in your house at any one time. And they limit the amount of cannabis material you can have in your house at any one time. For adult use cannabis grow, that is not allowed yet. The state will be promulgating regulations, but they want to get the legal market up and running before they allow it. And so I don't envision that the state will necessarily issue or allow home grow for adult use cannabis. Probably not until the end of 2023 or the beginning of 2024. I could be wrong, but there's a phase-in period there. It's in the law. The law actually states that they have until 18 months after the first retail sale to promulgate or allow homegrown use. So this does, and that's why they want to delay the legal home grow, because they want to establish a market here in New York and they want to get that up and running. So I hope that answers your question there. Matt has a question. Are you expecting sign regulations to come from the state level, or would that be covered exclusively locally? I think there are going to be extensive sign regulations that probably make most, if not all, local sign regulations irrelevant and unnecessary. I could be wrong, but I think there's in Massachusetts, they have extensive sign regulations. And if you look at it, if you go to Massachusetts or other states, Massachusetts in particular, because some other states are not as don't regulate as much as Massachusetts. Like if you were going to go to Colorado or Nevada for that matter, I mean, it's a little bit more free form or freewheeling out there. But in New York or in Massachusetts, it's pretty strict. And if you go to any of these places, you might not even tell that it's a cannabis dispensary unless you knew what you were going. You could walk past it and not even know. They're so nondescript, and the signage, it's not large. They do have signs for the establishment, but they're relatively innocuous. And again, I say this all the time. It's less, it's going to be less obnoxious or less busy than a liquor store or your convenience store. The stores are nicer than any of the other myriad establishments you have in a jurisdiction. And so, again, that's why I think it's very helpful to go and visit and see what they have in Massachusetts. So I will have 1 second here. I'm gonna upload very quickly again the latest copy of my handout here for those who are late to the program and didn't get a copy of it. You should see it in the chat box now. And thanks for joining. If you have any questions, I'll stick around, but I know I ran over my time a little bit.
Wade, do you want to put your contact information on the screen?
Oh, yeah,
so
absolutely. That's a good call.
Again, we'll archive this presentation so folks are able to come back to it. Wade, you're a panel of one, and this was a spectacular session. I think there was so much great material that you shared about the regulations. I'm on a board of zoning appeals, so personally, I'd like to see the state hand down side guidance so we don't even have to deal with it.
Yeah, I mean, I've told them this. I said the more that you can address that there is some concern at OCM that it's just going to be too onerous, and we're going to get out of control, the ZBAs and planning boards that just impose a whole bunch of regulations that are not helpful. I agree. And I told them, I said, the more you put in your regulations that address the concerns of local officials, that's the less, you're addressing this, right? Particularly with respect to, if you look at cannabis law section 131, it states that the time, place, and manners regulations can be imposed to the extent that they don't make it unreasonably impracticable as determined by the CCB. And I told the CCB, I'm like, tell us what unreasonably impracticable is. Just tell people, and people will live with that, right?
Yeah.
So,
well, I really want to thank you for shepherding us through this all by yourself. Mark, did you want to add any color commentary to?
No, Wade's killing it.
Yeah, absolutely.
I'd love to have him back in person in our fall conference that we'll be hosting at Hudson Valley Community College coming up in October sometime.
Well, hopefully we'll have the regulations by then, and I'll have more advice. I've been saying to be determined. I'm tired of saying to be determined. I can't, but I'm like, I wish I had an answer. And to be honest, I know, Phil, they didn't. I'm not sure what the OCM would have told you today if they were on the panel, because they don't have the answers, and they're not gonna say anything that they can't commit to yet. They're still in the process of crafting their regulations, and so I'm not sure how helpful it was, and then it would have eaten up my time, and that's who would want that?
Nobody would have wanted to see that.
Very comprehensive, Wade. Thank you. I will take this opportunity to tease our final session in the series. This was our penultimate session, so we're coming around the bend here, racing to the finish. Our next session will take place this Wednesday at 1 o'clock, and it is our case law update session. For those of you who are looking for some law credits, this is a case law update 2020 to present. The goal of that session will be the goal of the session is to provide guidance on how to prepare an administrative record to withstand an Article 78 challenge on a decision by a legislative body or a land use board. Really a great stuff for planning and zoning board members. Our speaker from Whitman, Osterman, and Hanna will review notable recent cases and discuss them in detail to evaluate how judges are examining the administrative records of decisions and basic types of approvals, such as adoptions to zoning changes, compliance with seeker, decisions to grant or deny site plans, subdivision and special use permits, and decisions to grant or deny requests for area variances. There's going to be a whole bunch of meat on the bone for that particular session. So really look forward to that one. And I hope people can make it. But again, thank you, Wade, for joining us today. Appreciate the opportunity to go into overtime. Your broad expertise on this is really welcoming, I think, to many of the municipalities out there who are struggling to understand the regulations and see what's coming up on the horizon. So.
They're not alone. My pleasure. Anything I could do for you, don't hesitate to call or email.
All right. Thanks.
Well,
Mark, got the session on Eventbrite, and I want to wish everybody a happy Monday. So take care.